Welcome back to Exhibit A List, where pop culture gets cross examined. I'm your host, Jasmine Wegg. I'm a lawyer, and this week we're doing a pop culture legal roundup because there's been a lot that's happening. We've got the biggest social media trial potentially ever, updates on Blake Lively versus Justin Baldoni, a reality TV show that turned into an actual lawsuit, the original Mahoney cast defecting to a rival network, and a major win for authors suing OpenAI. Quick reminder before we jump in, you can find me on Instagram at JasmineWegESQ and follow the podcast at Exhibit A List Pod. And you can find me on TikTok at Jazz the Lawyer. If you like this episode, the best way to show love is to follow the podcast, leave a rating, review, share it with a friend. All right, let's get into it. So, the biggest story of this week is the social media addiction trial that started Tuesday, January 28th in LA Superior Court. And when I say this is big, I mean that the stakes are astronomical. Here's what's happening. A 19-year-old plaintiff who's being identified as KGM is suing Meta, YouTube, TikTok, and Snapchat, claiming that these platforms addicted her as a minor and caused depression, anxiety, suicidal thoughts. TikTok actually settled on Monday, right before the trial actually started. Snap settled last week. Terms of both settlements, unfortunately, are confidential because when you enter into a settlement agreement, one of the key provisions is that you can't disclose what's in the settlement terms. And that's because the reason sometimes people are settling is to avoid the publicity around a court decision. Now we just have Meta, which is Instagram and Facebook, and YouTube facing trial. There are over 1,600 plaintiffs in total in these related cases. 350 families and 250 school districts are all making similar claims. KGM's case is the first one to go to trial, and the outcome will influence how all the other cases are going to get resolved. So if Meta and YouTube lose on KGM's, we're talking about potential damages in the high tens of billions of dollars. Mark Zuckerberg is expected to testify in February. The trial could last 6 to 8 weeks. Now, let's talk about what KGM is actually alleging. She claims that she started using these platforms when she was around 11 or 12 years old. She says features like infinite scroll, autoplay, push notifications, and the way content is algorithmically fed to you were all deliberately designed to be addictive. The lawsuit argues that these companies knew their products were harmful to kids and did it anyway because user engagement meant more ad revenue. And there's evidence to support this. There are internal documents that have been produced through discovery from Meta that has been unsealed, and they reportedly show Meta's own research found that Instagram made body images worse for teenage girls, increased the rates of anxiety and depression, and that executives knew about these harms, but they did not make changes. One document that's been widely reported has included this quote from a Meta researcher who says that among teens who reported suicidal thoughts, 13% of British users and 6% of American users trace those issues back to Instagram. So there's some knowledge there, at least as produced in the discovery. The plaintiffs are arguing that this is a products liability case. So, in other words, they're saying that these platforms are creating defective products. So, in other words, they're saying that these platforms are defective products that cause harm. So, think about it like the tobacco lawsuits. Cigarette companies knew smoking caused cancer, marketed it to kids anyway, and eventually they had to pay billions of dollars in settlements and change how they did business. The defense that Meta and YouTube are mounting is twofold. So they argue that Section 230 of the Communications Decency Act, which says that platforms aren't liable for content posted by users, is a protection for them because they're not the ones actually posting the content. But the plaintiffs are pushing back and saying that this is not about the user generated content. It's about the design of the platforms themselves, the addictive nature, the algorithms, the way notifications are engineered to keep you coming back. And then the second defense for the platforms is a First Amendment argument. Meta and YouTube are saying that their algorithmic curation is protected speech and that regulating it would violate the First Amendment. The plaintiffs counter that the product design isn't speech, and I agree there. Like, if they're arguing that the products are designed in a defective manner and that they cause harm, I don't think you can respond that this is protected speech because we're talking about the design of the platform. The plaintiffs are basically saying that their conduct and the dangerous products can be regulated. Now, Meta just reported earnings this week, and they included a warning to their investors that if they lose these cases, they could face a material loss. So that's corporate speak for this could cost us lots and lots of money. Analysts are estimating the financial exposure could be in the hundreds of billions of dollars if you count all of the related cases. And here's where it gets interesting from a broader perspective. There's a huge debate happening right now whether social media is actually bad for kids or whether the problem is parents not monitoring their kids' usage. Meta and YouTube are likely going to argue that the parents are responsible for what their kids do online. And I think we can all agree that parents take a front and center role in monitoring their children and their usage. The the platforms are going to say that there's features like parental controls and screen times. Parents can limit screen times, and it's not the company's job to parent your children. But the plaintiffs are going to push back and argue that these platforms are so deliberately engineered to be addictive that even adults struggle to moderate their use, let alone children whose brains are still developing. They'll point to the internal research showing that Meta knew the harms and they still targeted kids anyway. Here's the thing, both sides have a point. It's not only one side that's correct. Parents should absolutely be monitoring what their children do online. But also, if a company designs a product and they know it's harmful to children and then they market it to children, that feels like it should come with some accountability. I think what makes these cases so compelling is that it's asking a question that we've all been wondering. Are these companies responsible for the mental health crisis among children and teenagers? Because the data is pretty stark. Teen depression, anxiety, self harm, suicide rates, they've all spiked in the years since social media has become ubiquitous. Is that correlation or causation? We don't know. Obviously, other things have changed over the years as well. But this trial is going to explore that debate. The fact that TikTok and Snap both settled right before trial does tell you something. It gets my flags up as a lawyer. They clearly didn't want a jury to hear evidence. No one runs into trial if they think they have a slam dunk clear shot of winning and they have nothing bad that's going to come out against them. Settling means they don't admit any wrongdoing. They don't set a precedent, and then they also control the financial hit because it's unknown how much a jury would ultimately award the plaintiff, and they can decide however much they want to offer in settlement. Going to trial is always a gamble, and they chose not to take it. Meta and YouTube, on the other hand, are going to fight. Meta, especially, has been very aggressive in these cases. They're arguing that the science does not support the claim that social media causes mental health issues. They point to studies that show mixed results. They say kids who are already struggling gravitate towards social media. In other words, that the struggling kids are more likely to be on social media and that social media is not creating the struggle. But the plaintiffs have their own experts who are going to testify that yes, the platforms do cause harm and that the design features are intentionally manipulative. One more thing to note, this trial is being compared to the big tobacco litigation, but there's a key difference. Tobacco companies eventually settled and agreed to massive restrictions on marketing, especially to kids. Social media companies have fought every regulation, tooth and nail. They've lobbied against laws that would restrict how they operate. They've argued that any attempt to regulate them is unconstitutional. So if the plaintiffs win, we could see a fundamental shift in how these platforms operate. We could see regulation that bans certain features for users under 18. We could see mandatory disclosures about addictive design. I'm talking about you open up TikTok or Instagram and right before you start to scroll, it says warning, this app is known to cause addictive behavior or can be addictive. So proceed with caution if you scroll, whatever the language they intend to use. Imagine how you'd feel after you see that. We could see age verification requirements. We could see platforms having to prove their products are safe before they can market to kids. Or if Meta and YouTube win, we can see the opposite, a green light for platforms to continue operating the way they always have, with the message that it's on the parents and users to protect themselves. So I'll be watching this trial closely and I'll update you as it develops because it's a huge deal. All right, speaking of huge deals, let's talk about the latest in Blake Lively versus Justin Baldoni. Last week, a voice message from Blake to Justin was unsealed as part of the discovery that's being unsealed these past 2 weeks. And in the message, Blake is asking Justin if they can push back the start of filming for It Ends With Us because she had just had a baby and she didn't have a nanny yet. She was feeling overwhelmed about getting back to work so quickly. She says things like, selfishly, I would love it if we could go a couple weeks later. And she talks about being stressed about not having time to work out and prep for this role. The tone sounds friendly, almost apologetic. She's saying, I'm not trying to move anything, but if by chance you wanted to go earlier, that would help. Now, people who are Team Baldoni argue that this voice message supports their argument that Blake was difficult to work with and was trying to control the production. People also say that she opened up the topic of her body and her weight, which she says that was part of the harassment, that he talked about her weight and things like that. So people are looking at this message, which came before they began to film, as evidence that she opened the door to make it okay for him to talk about her weight. Do we think that if someone opens the door and gives them the other person a full pass to discuss our weight? I don't know. On the other hand, supporters of Blake look at this voicemail and say she was being collaborative and that she was asking and not demanding that he work with her on scheduling issues. Ultimately, most people agree that this voice message is not a smoking gun. It will help Baldoni bolster his defenses ultimately, and Lively might even use it in support of her effort to show that she was being collaborative. It doesn't seem like much, but what's crazy about this voicemail is we have it in the public domain. Like I've been saying, as all of these documents, emails, texts, and now voice notes are getting unsealed, it's just strange that we now can hear the inner workings of these celebrities who, like, we don't normally hear the way they interact with one another, their private messages that they never intend to be public. We're in a weird possession we're in a weird position to litigation. We now are privy to things that were never meant to be public. And we start to see sides of celebrities that were never really meant for us to see. So right now we're likely looking at trial in May, where all of this is going to come out in open court. Blake will testify, Justin will testify, Jenny Slate will probably testify, Ryan Reynolds might testify, and Taylor Swift could even be called as a witness. All those text messages and emails that were unsealed last week will be exhibits at trial, most likely. And the jury is going to see all of it and determine whether it's probative. Something interesting is that the unsealed documents also included text messages where Blake discussed the meetings that she had with Baldoni and the producers in January 2024 before they resumed filming. That's the meeting where she laid out 17 conditions for a safe working environment, including no improvised kissing, no discussions of Baldoni's sex life, no showing Blake nude videos or images of women, etc., etc. And during her deposition, Baldoni's lawyer kept asking Blake why she didn't use the term sexual harassment during that meeting, but instead she kept calling them HR claims. Blake's response was basically, I described what happened and it was pretty obviously sexual harassment, even if I didn't use that exact phrase. So you can see another point where they're going to argue. They're going to use how she referred to that meeting as determinative of whether she considered what was happening HR issues or actual sexual harassment. They're playing around with semantics there too. So that's where we are with Blake and Justin. The case is moving toward trial and it's going to be a media circus. Okay, here's an interesting one. A reality TV series about the NYPD has turned into an actual legal drama. The show was tentatively titled Behind the Badge and was supposed to be a spotlight to the New York Police Department. It was being produced by Jordan McGraw, who is the son of Dr. Phil. Dr. Phil was going to host the series, interviewing officials and showing up at crime scenes. The show was supposed to air on Dr. Phil's Merit TV, cable, and streaming channels. But the city abandoned the project late last year, and then they sued Jordan McGraw and the production company for breach of contract this week. Here's what happened. The city gave McGraw's company special behind the scenes access to the NYPD. They had a production agreement that gave the city final say over content. The agreement said the show was intended to highlight the extraordinary work of the NYPD and that McGraw couldn't include certain things like sensitive operations, identities of undercover officers, crime victims, or witnesses. But according to the lawsuit, the rough cuts that McGraw provided to the city were mostly unedited footage dumps. and included material that violated the agreement. The city says that the footage showed things like an officer inputting a security code at a police station entrance, discussions of encrypted police communications, and unblurred faces of people who were arrested but hadn't been convicted. The city also claims that the show portrayed the NYPD negatively at times, which violated the agreement. So the city tried to work with McGraw to make edits, but according to the lawsuit, McGraw's company disavowed their obligations and tried to take editorial control away from the city. The city says that McGraw Media indicated that it would not accept the city's edits and was looking for a buyer to air the show with the flagged content included. So the city sued and got a court order blocking McGraw from selling or disseminating any of the footage. McGraw's lawyer said that the lawsuit was a surprise because publication of any programming was not imminent and that they had been working with the city to address the requested edits. The lawyer called the court order a presumptively unconstitutional prior restraint. And here's the legal issue. Prior restraint is when the government tries to stop something from being published before it's published. That's generally unconstitutional under the First Amendment. There are very narrow exceptions like national security, but they're rare. So McGraw is arguing that this is a First Amendment violation. The city is arguing that this is a breach of contract case, and McGraw signed an agreement giving the city approval rights. The case has gotten moved from New York State Court to federal court last week, so now a federal judge is going to have to sort this one out. And here's the kicker. The city partnered with McGraw on this show last April, one day after federal corruption charges against then Mayor Eric Adams were dismissed. And it recently came out that Adams' campaign paid $500,000 to another one of McGraw's companies to produce social media ads. So there's a whole political angle here too about whether this was more about PR for Adams than it was about showcasing the NYPD. Adams has defended McGraw, saying that he brought exceptional talent in revealing the inside story of the dangers NYPD officers face every day, and that McGraw meticulously addressed every concern raised by City Hall. But the city's lawsuit tells a different story. We'll see how this one plays out, but it's a good reminder that when you sign a production agreement with a government entity, you're probably not going to have full editorial control ever. All right, quick reality TV update. The original Real Housewives of New York City cast is coming back, but not on Bravo. According to reports, Luann de Lesseps, Sonia Morgan, Jill Zarin, Kelly Ben Simone, and Ramona Singer are working on a new show for E! But here's what's wild. Bravo and E! Used to be under the same NBC Universal umbrella, but NBC Universal spun E! Off this month. So now it's owned by a new company called Versant. So Bravo and E! Are now essentially competitors. Bravo created Rahoni. The original cast became famous because of Bravo, and now those same women are going on a rival network competing against Bravo. The backstory is that Bravo tried to do a Real Housewives of New York legacy show and with the original cast back in 2023, but talks fell apart over money. Meanwhile, Bravo rebooted Real Housewives of New York with an entirely new cast after season 13, and that was a disaster. The new cast has not won over fans. Ratings have been bad. The show is currently not on Bravo's schedule while producers try to figure out what to do. And we all know that there is a certain magic that Luann, Sonia, Jill, Kelly, and Ramona bring, but they do need Bethany and Dorinda, but they still got that magic. And let's be honest, you can't replace it. So the original women basically said, fine, we'll take our Pinot and our drama elsewhere. From a legal perspective, the question is whether Bravo has any recourse. Do these women have non-compete clauses in their contracts? Because it's been so long since they were contracted with Bravo. I don't know how long those non-competes lasted for. Can Bravo stop them from doing a similar show on a competing network? The answer is probably no. Reality TV cast members typically don't have long restrictive covenants that would prevent them from working on other shows. They might have clauses that say they can't appear on competing shows while they're under contract with Bravo. But if they're no longer on Mahoney, those contracts have likely expired and it's been a while. Bravo could try to argue that the women are violating some kind of intellectual property rights because, like, the IP in Real Housewives, which is a production of Bravo, maybe Bravo owns the personas or the catchphrases or something, but it's probably a reach. The reality is that once someone becomes famous on your show, they have the right to leverage that fame elsewhere. Bravo doesn't own these women. According to Page 6, the new E! Show could arrive as early as the end of this year. I'm personally excited for it. We'll see if it happens and whether it's any good, but it's definitely a blow to Bravo's dominance in the reality TV space. Okay, last story. On January 5th, a federal judge ordered OpenAI to turn over 20 million ChatGPT logs to plaintiffs suing them for copyright infringement. This is a huge deal for the AI copyright litigation that's been playing out. Here's the background. The New York Times, the Chicago Tribune, and a bunch of authors have sued OpenAI. They're claiming that the company used their copyrighted works to train ChatGPT without permission. The lawsuits are asking a multi-billion-dollar question. Can AI developers train their models on copyrighted works without the permission under fair use? As part of discovery, the plaintiffs wanted access to ChatGPT conversation logs to prove their case. They initially asked for 120 million logs. OpenAI said that was way too much, and they countered with 20 million logs, which is about 0.5% of the tens of billions of logs they have. The plaintiffs agreed. But then OpenAI tried to change the deal. In October 2025, they said instead of giving plaintiff all 20 million logs, they wanted to run keyword searches and only produce conversations that mentioned plaintiff's works. The magistrate judge said no. And last week, the district judge affirmed that ruling and said OpenAI has to produce the full 20 million logs. OpenAI's argument was twofold. First, they said logs that don't mention the plaintiff's works aren't relevant. Second, they said producing those logs would invade ChatGPT users' privacy, which, by the way, you got to realize that you don't have an assumption of privacy when you're using ChatGPT. This case is proof of it. The court disagreed on both points. On relevance, the judge said that even logs without direct reproductions of plaintiff's works are discoverable because they're relevant to OpenAI's fair use defense. Fair use analysis looks at whether the AI's outputs compete with or substitute for the original work. So logs showing what ChatGPT produces across all types of queries would actually reveal a pattern that is relevant to the analysis. On privacy, the judge acknowledged that ChatGPT users have legitimate privacy interests in their conversations, but the court said that those interests are protected by three things: reducing the sample from tens of billions to 20 million logs, OpenAI's de-identification process to remove personally identifiable information, and the existing protective order in the case that limits who can see the logs and how they can be used. So I guess it's not open to the public. The judge also distinguished this case from one that OpenAI cited involving wiretapped involving phone calls. The judge said that ChatGPT users voluntarily submitted their communications to OpenAI. They were not recorded secretly, so the privacy interests are different. For OpenAI, this is a big loss because now the plaintiffs are going to have access to millions of data points showing exactly how ChatGPT is being used. If those logs show that users are asking ChatGPT to summarize New York Times articles, or that ChatGPT is producing outputs that are substantially similar to copyrighted works, that's going to be a very bad for OpenAI's fair use defense. It also sets a precedent for other AI copyright cases. There are dozens of similar lawsuits against OpenAI, Microsoft, Meta, and other AI companies. This ruling basically says that user conversation logs are discoverable, and AI companies can hide behind privacy concerns to avoid producing them. One expert said, for OpenAI, this decision is certainly a legal debacle, which will inspire other plaintiffs in similar cases to do the same, to prevail in courts to get much better settlements from AI companies. In other words, they're going to use it as leverage. Another expert noted that this is a reminder that even if you think your ChatGPT conversations are private, they might end up being produced in court someday. The architecture of these AI systems means that even if some user-facing systems are configured to delete chat logs, other parts of the tech stack might preserve them. The discovery could be pivotal. If plaintiffs can demonstrate that ChatGPT routinely generates outputs that compete with or substitute for copyrighted content, OpenAI's fair use defense becomes a lot harder to sustain. So that's the OpenAI update. The case is still in the discovery phase, but this ruling was a major win for the plaintiffs. Before we get to I just wanted to briefly acknowledge that there's been a slew of famous names released daily in the Epstein files by the DOJ. I'm not going to cover this case in detail because, frankly, it's too disturbing for our lighthearted podcast. But if you're following it, just know that new documents keep getting unsealed and more names keep coming out. It's a reminder that discovery and litigation eventually becomes public, and things people thought were private can end up in the news. In this case, they should. All right, that's what I've got for you this week. The social media trial is just getting started, and I'll keep you updated as it goes. Blake versus Justin, it never ends with them. It's heading toward trial, though, in May, so we'll have updates all the time. Don't you dare worry. Rahoni cast defecting to E, and OpenAI has to hand over 20 million ChatGPT logs. If you found this breakdown helpful, please share this episode with a friend who's been following any of these stories. And if you haven't already, please take a second to follow the podcast and leave a rating or review wherever you're listening or watching. You can find me on Instagram, JasmineWegESQ, or the podcast Exhibit A-List Pod. And I'm also on TikTok, Jazz the Lawyer. Come tell me what you think about any of these cases. Thank you for listening, and I'll see you next time on Exhibit A-List. Stay curious.